When the Indian Constitution came into force back in 1950, it wasn't just some dusty old rulebook. It was really a promise made to every single citizen of a new nation, one that was going to be built on dignity, liberty, and justice. And right at the very core of that promise, you'll find the fundamental rights. They're like a shield for every individual. So let's explore how this shield was forged, and more importantly, how it actually works. And this quote from Justice Bhagavati, it just perfectly captures the spirit of what we're talking about. It's not just about, legal rules. It's about creating an environment, a society, where every single person can actually reach their fullest potential. That idea is the bedrock of everything we're going to discuss. So, that big promise, it's all laid out in Part 3 of the Constitution. You can think of it as the beating heart of the entire document. It's a list of rights that are basically non-negotiable, the very foundation of Indian democracy. But here's the thing about a shield, right? It's only useful if it's actually protecting you from something. And that is the million-dollar question, isn't it? These rights, they're a check on power. They draw a line in the sand that just can't be crossed. It's what establishes a government of law, not of men. And the main entity this shield is designed to protect you from is what the Constitution calls the state. Okay, so what exactly is the state? Well, Article 12 gives us the definition. It's basically the entity that has a duty to respect your rights. And if it doesn't, it's the one you can drag to court and hold accountable. The whole concept is designed to be incredibly broad. So Article 12 breaks the state down into 4 big parts. Now, the first 3 are pretty straightforward, right? You've got the central government, all the state governments, and then local bodies. Think your city's municipal corporation. But it's that last one, that 4th category, other authorities, that's where things got really interesting and opened up a huge legal can of worms. Exactly. I mean, what does that even mean? The thing is, this phrase is kind of vague on purpose. See, in a modern country, the government doesn't just work through its main departments. It sets up all sorts of corporations, boards, and other bodies to do public work. So, the big question was, should these bodies get a free pass to violate your rights just because they aren't technically the government? Well, the judiciary had to step in and figure that out. And this is the test the Supreme Court came up with. What's so brilliant about this is how the court decided to look past the label, past the legal form, and look at the actual function. So if an organization looks like the government, acts like the government, and is controlled by the government, well then for the purpose of your fundamental rights, it is the state. This move dramatically expanded who is actually accountable to the people. All right, so we've figured out who your rights protect you from. But what happens when the state actually passes a law that smacks right into one of these rights? Who blows the whistle and calls a foul? The whistleblower is Article 13, and its job is simple but incredibly powerful. It basically says that any law, doesn't matter if it was made before or after the Constitution, that messes with a fundamental right is, well, void. It's the Constitution's built-in quality control system. But the courts don't just come in with a sledgehammer to knock the whole thing down. They've developed these really clever legal tools. With the doctrine of severability, they can act like a surgeon, carefully removing just the unconstitutional part of a law and leaving the rest of it to work. And then there's the doctrine of eclipse, which is fascinating. An old law that clashes with a new right isn't totally killed off. It just becomes dormant, eclipsed. It's just sleeping, and it can even be woken up again if the Constitution is ever changed in a way that removes the conflict. Okay, this all leads to the biggest, most fundamental question of all. We've been talking about ordinary laws, but what if Parliament tries to amend the Constitution itself? What if they try to change the very rules that give us these rights in the first place? This very question kicked off a dramatic, decades-long tug-of-war. Seriously, it was a showdown. At first, in 1951, the court said Parliament had unlimited power. But then, in 1967, in the Goloknath case, it did a complete reversal, saying fundamental rights were sacred and couldn't be touched. This massive standoff was finally resolved in 1973 with the legendary Kesavananda Bharati case, which gave us a grand compromise that was later solidified in the Minerva Mills case. And that grand compromise is what we call the basic structure doctrine. Here's the key takeaway. Parliament's power to amend the Constitution is huge, but it's not absolute. It can't use its power to destroy the core identity of the Constitution itself. The analogy I love is that it can renovate the building, but it can't just demolish the foundation. So what exactly is this basic structure? Well, the court has been pretty smart about this. They've never given us a complete final list.
They decide it on a case-by-case basis. But some of the core pillars we know are part of it include things like judicial review, secularism, the rule of law, basically the absolute non-negotiables of the Constitution.
Okay, so there's one last really crucial layer to all of this. We've spent all this time talking about how powerful these rights are. But, and this is a big but, that doesn't mean they're absolute. Look, no right can just exist in a vacuum. There's that old saying, right? Your right to swing your arm ends where another person's nose begins. The Constitution totally gets this. It allows the state to put reasonable restrictions on these rights in order to protect the wider public good.
And this is a perfect example of that balancing act in action. Let's take Article 19, the right to freedom of speech. You absolutely have this right. But it can be reasonably restricted for things like maintaining public order, protecting national security, or preventing somebody from being defamed. It's a trade-off.
But the key word here, the real constitutional safeguard, is reasonable. A restriction can't just be random or way over the top. And ultimately, it's the judiciary, the courts, that act as the umpire. They're the ones who decide if a restriction from the government is truly reasonable or if it's just an abuse of power. So when you put all these different pieces together, you have the shield, you have the enforcer, you have the ultimate safeguard, and you have this balancing act. What you see is a constitutional framework that isn't just frozen in time.
I mean, just think about it. The meaning of these rights has evolved over time. The definition of the state got bigger to keep up with how a modern government works. The basic structure doctrine was literally invented by judges to protect the very soul of the Constitution. This proves that fundamental rights aren't just dead letters on a page. They are a living, breathing, constantly evolving conversation that shapes the nation every day.
And that process of interpretation, it never, ever stops. For example, rights like privacy and education, they were read into the Constitution by the courts decades after it was first written. So that brings us to a final thought for you to chew on. When you look at the challenges we face today, which fundamental right do you think is next in line for a big, transformative reinterpretation?